Welcome back. In today's lecture, we will be covering a very important landmark judgment of S.R. Bommai versus Union of India. This case had a huge impact on the center-state relationship. The date of the judgment was 11th March 1994. It was a 9 judges bench, and before we get into the further the dictum or the verdict, we should know some facts about this case. So let's begin with the facts of the case. So who was the S.R. Bommai? S.R. Bommai was the chief minister of the Janata Dal government in Karnataka between August 13, 1988 and April 21, 1989. His government was dismissed on April 21, 1989 under Article 356, that is the President Rule, as we know, of the Constitution of India. So the President Rule was imposed there. The dismissal was on the ground that Bommai government had lost the majority following large-scale defection engineered by several party leaders of the day. So now what happened then? The governor, the then governor P. Venkata Subbiah, refused to give Bommai an opportunity to test his majority in the assembly. So this was the exactly the facts regarding the S.R. Bommai case. Now what Mr. S.R. Bommai did? S.R. Bommai went to the court against the governor decision to recommend President Rule, moved to the Karnataka High Court. So, and it was dismissed because his writ petition was dismissed. Then the only options left with Mr. S.R. Bommai was to move to the Honorable Supreme Court. So now see, in the present case, how the Honorable Supreme Court decided. On 11th March 1994, 9 judges Constitution bench of the Supreme Court of India issued a historic order, which in a way put an end to the arbitrary dismissal of the state government under Article 356 by spelling out the restriction. So in the present case, it was stated that by our 9 judges Constitution bench of Honorable Supreme Court that power of the president to dismiss the state government is not absolute. So it is not an absolute power, and even the president, honorable president, should exercise this power only after his proclamation is approved by both the House of Parliament. So friends, first thing is important under Article 356. Whenever in any state there is the state machinery is failed, and if the president, our honorable president, imposes the president rule, so this power must be exercised only after the approval by the both House of the Parliament first. Okay. Till then, the president can only suspend the legislative assembly. Means till the time this approval is given, the president only, honorable president, can only suspend the legislative assembly. And if the presidential proclamation is not approved by the parliament, that is both the house of the parliament obviously, then this proclamation of the honorable president lapses at the end of the 2 month period. Now the next important point here is that 2 month period, after lapse of the 2 month period, this proclamation lapses if not approved by both the house of parliament. Okay, now see, the legislative assembly which may have been kept in the suspended animation gets reactivated. So once it lapses, the legislative assembly of the state actually reactivates. Okay, now the court made it very clear that the presidential proclamation under Article 356 is also subject to the judicial review. So if I will read the judgment clearly, I find that the Honorable Supreme Court held that the power to impose the president rule in the state whenever there is a constitutional failure of state machinery fails. So the honorable president can do that, but the proclamation must be approved by both the house of parliament, and if not approved, then after the lapse of 2 months, automatically this proclamation lapses. Okay, so comes to an end. And also this is subject to, this proclamation which is being issued is subject to the judicial review. Okay, this is very very important, judicial review. Okay, by the courts. Now the case put an end to an arbitrary dismissal of the state government by a hostile central government. The ruling laid down the law that only way to determine support enjoyed by the particular state would be by means of the floor test. So one important point which has been laid down in this case is that floor test, a concept of the floor test. So if we want to determine the state government, actually what is the status of the state government, so the floor test should be there first. Okay, and actually the governor should actually explore the other ways and other avenues first before means opportunity should be given to the state legislature or the government to prove his its majority. Okay, so very important thing. Now see, floor test is also done here. Now the president, honorable president, shall have unconditional power to dissolve the state government is when there is a complete breakdown of the constitutional machinery. So if the ground is asked, under what ground the state government can be dissolved by the unconditional power of the president, by the president. So whenever there is a breakdown of constitutional machinery. So very important point, you must know that in such only cases this is the only ground actually. Okay, now the SR Bommai was the judgment. It was a landmark verdict which put restriction on the center for imposing the president rule on the states. So with this note, I want to say that this was a very important landmark judgment regarding Article 356, and I think I made a lot of points clear to you. I want to make this point once again. I want to recall all these points under Article 356. The very first important point is that the power to impose the president rule in the state is not the absolute power. Okay, it is it can be imposed only after the such proclamation is approved by both house of the parliament. The very first important point. The second important point is that such proclamation, the proclamation issued by the president in the state, is subject to the judicial review. So we can the courts, honorable Supreme Court, can check whether there is any substance regarding it or not. Even the governor should also find other avenues, and opportunity should be given to the state government to prove, means by means of the floor test, the majority by means of the floor test. Okay, so this was another very important point, is that okay. Now the final conclusion given in the whole judgment is that the power should be exercised with with an application of mind, and due application of mind, and not mechanically. So with this we have actually covered this very important judgment of the SR Bommai versus Union of India, and it was a 9-judge bench. Please mark it, it was a 9 judges bench. Okay, and I think all the points regarding this case is very much clear to you. So friends, first of all, you can check the playlist also, where I am always going to provide the judgments, and we discuss very important points which might come in your exam. So till now we have actually we have covered the Joseph Shine judgment. Okay, we have also talked about the ADM Jabalpur judgment, and so many other judgments I have talked about, like Keshwanandan Bharti case, like basic structure, and when you will go, you will find that AK Gopalan case we have discussed, Menka Gandhi versus Union of India we have discussed. Okay, so you just check the playlist wherein I have provided, and I will be uploading all the landmark judgments of our honorable Supreme Court, which is very important for the CLAT exam, for any other state judiciary exams. So you can you please subscribe also, and keep updating. There is so many material regarding the world history, UN Charter, United Nations, okay, and also the constitution and polity videos are also available. So with this note, thank you. I want to say thanks for listening, and God bless. Take care.